Hello everyone, this is Urvashi Chauhan. Welcome back to another episode of Courts Today by Livelaw, where we bring you the latest developments from all courts across India. Let us start. A bench of Justices Aniruddha Bose and Bela M. Trivedi today heard former Andhra Pradesh Chief Minister Chandrababu Naidu's plea challenging the Andhra Pradesh High Court's order, which had declined to quash FIR against him in the skill development scam case. Today, the Apex Court asked if the court could adopt an interpretation of Section 17A of Prevention of Corruption Act, which will defeat the objectives of the Act. Senior Advocate Harish Salve, appearing for Naidu, argued that Section 17A was inserted to curb the instances of regime revenge, that the inquiry in the present case had commenced in 2021 and therefore Section 17A was applicable because any inquiry or investigation launched against a public servant after the 2018 amendment will require sanction regardless the date of offence. Salve also said that the state had filed certain documents before the Andhra Pradesh High Court after the arguments in the case were over. These documents were to show that the inquiry in the matter commenced before the 2018 Amendment to Prevention of Corruption Act. Naidu is challenging his arrest in connection with the skill development scam case on the ground that Andhra Pradesh CID had not obtained sanction of the governor before adding him as an accused in the case. The arguments in the matter will continue tomorrow. You can visit our website to read the arguments in detail. I am sure you remember the political drama which unfolded in Maharashtra this year in July. The issue arose when a section led by Ajit Pawar and Praful Patil broke ranks with NCP Supremo Sharad Pawar and joined hands with the BJP and Shinde Sena. Ajit Pawar was sworn in as the Deputy Chief Minister and 8 other NCP MLAs took oath as ministers in the Eknath Shinde-led government. The matter reached to Supreme Court when the Sharad Pawar faction, through MLA Jayant Patil, filed a petition before the Supreme Court against the delay by Maharashtra Assembly Speaker Rahul Navelkar in deciding the disqualification petition filed by official NCP against rebel MLAs led by Ajit Pawar. Today, a bench comprising CJI Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra issued notice in the petition. The bench decided to list the petition on coming Friday along with the Shiv Sena case. As you already know that in the Shiv Sena case last month, the Supreme Court had issued directions to the Maharashtra Speaker to decide the disqualification matters in a time-bound manner. Though Senior Advocate Mukul Rohtagi, appearing for Ajit Pawar faction, today said that the facts in both the cases were different, still both the matters have been listed together. In another update from the Supreme Court, it has directed the chairperson of Principal Bench of the Armed Forces Tribunal, that is AFT, to file in a sealed cover a report to the Registrar General of Supreme Court. The report is to indicate the circumstances under which he passed order of transfer of Justice D.C. Chaudhary. This matter relates to Justice Dharamchand Chaudhary's transfer. A judicial member of AFT Chandigarh, he was transferred to the Calcutta bench just before he was about to hear a contempt case against an officer of Defence Accounts Department for not implementing orders of grant of disability pension to army personnel. Post this, a plea was filed by the Armed Forces Tribunal Chandigarh Bar Association alleging that Defence Ministry was interfering in the judicial process by causing transfer of Justice Chaudhary. The counsel for the Bar Association said that this was a case of res ipsa loquitur, that is, when the facts speak for itself. He alleged that the tribunal was being controlled by the Defence Ministry, which had on multiple occasions refused to implement the orders of the tribunal. As a result, 600 applicants were stuck. He also highlighted the background of Justice Chaudhary's transfer, explaining about previous occasions of transfer of cases dealt with by Justice Chaudhary to the principal bench. Today, a bench comprising CJI Chandrachud, Justice J.B. Pardewala and Justice Manoj Mishra said that the circumstances in which the judge had been transferred would merit close scrutiny. The bench also held that pending further orders, Justice Chaudhary was not required to assume office at Calcutta. The matter has now been listed for 12th October. Stay tuned with us. Yoga Guru Ramdev's alleged remarks on allopathy or modern medicine during COVID pandemic had caused quite a controversy. Ramdev, who is also the founder of Patanjali Yogpeeth, an institution focused on yoga and Ayurveda research, had criticized doctors for the treatment methods adopted for COVID-19. He also claimed that lakhs of people had died after taking allopathic medicines for COVID-19. Although he later reportedly withdrew his statement, his controversial remarks led to multiple criminal proceedings. He has approached the Supreme Court praying that FIR filed against him at various places should be clubbed together and transferred to Delhi or be quashed. The Supreme Court bench comprising Justices A.S. Bopanna and M.M. Sundaresh heard the matter today. Ramdev's counsel, Senior Advocate Siddharth Dave, argued that his comments about allopathy medicines may have offended doctors but did not amount to any offense. That the statement was one, but people in different states had taken offense to it, causing various complaints. Senior Advocate P.S. Patwalia, representing the Indian Medical Association, raised objections regarding the prayers in the petition and said that the FIRs filed in Patna and Raipur had different causes of action. He also referred to their affidavit about how Ramdev had come out with a medicine called Coronil and had made false statements that it cured COVID-19. But Senior Advocate Dave objected to the affidavit, saying that without notice being issued, an affidavit could not have been filed. Eventually, the court issued notice in the matter and sought the responses of Union of India, Bihar and Chhattisgarh governments and the Indian Medical Association. And now coming to an update on the UPSC Civil Services exam case. As you know, 3 petitioners challenged UPSC's decision to treat them as general category candidates post results, calling the action to be arbitrary. According to the petitioners, they were initially categorized as economically weaker section, that is EWS candidates, having scored above the EWS cutoff marks. However, UPSC changed their category to general after the results were declared in May this year, without providing any reason. The petitioners had provided the required income and asset certificate for the financial year 2020-21 within the stipulated deadline. In January this year, UPSC informed them that their EWS certificates incorrectly mentioned the year 2021-22, which should have been 2021. Following this, a clarification was also issued by the competent authority where they acknowledged a clerical error in the certificate and confirmed that it should be read as financial year 2021. The petitioners submitted their certificates with this clarification during the interview but were later not selected in the final results. The Supreme Court had reserved its judgment last month on the matter and today has dismissed the petitions. The court held that UPSC was justified in rejecting the candidate's claim for EWS quota for not submitting the requisite certificates before the prescribed cutoff date in the specified format. A bench comprising Justice J.K. Maheshwari and Justice K.V. Vishwanathan further held that civil service examination rules have the force of law and upheld the constitutionality of the rules. The bench also said that any candidate not in possession of the income and asset certificate in prescribed format cannot claim the benefit of EWS category. That UPSC was justified in rejecting the candidature of those candidates claiming benefit under the EWS category as they submitted the income and asset certificate beyond the stipulated deadline. The Supreme Court today allowed Mohammad Faisal to continue as Member of Parliament representing Lakshadweep and has stayed the Kerala High Court order which refused to suspend his conviction. The background here is, in January this year, Faisal and 3 others were convicted and sentenced to 10 years imprisonment by Kavarati Sessions Court for attempting to murder Muhammad Salih, son-in-law of former Union Minister P.M. Syed, during the 2009 Lok Sabha polls. So he was disqualified from the membership of Lok Sabha. Against the punishment, Faisal approached the Kerala High Court, which suspended the conviction and sentence imposed on Faisal. Then, the Union Territory of Lakshadweep and the complainant approached the Supreme Court against the order suspending his conviction. In August, the matter was remanded back to the Kerala High Court for reconsideration. And the Apex Court also ordered that the benefit of suspension of conviction would continue. But last week, when a single bench of Justice N. Nargesh of Kerala High Court was hearing the matter afresh, it refused suspension of his conviction. Today, the Supreme Court has stayed this order. A bench of Justice Rishikesh Roy and Justice Sanjay Karol also said that benefit of suspension of conviction would continue, thus permitting Mohammad Faisal to continue as a member of parliament. The court has also issued notice returnable in 4 weeks in his plea. The position of Chief Justice at the Manipur High Court has been lying vacant since February this year, despite Apex Court's collegium recommending Delhi High Court Judge Siddharth Mridul's name in July. Currently, Justice M.V. Muralidharan is serving as Manipur High Court's acting Chief Justice. Also, Manipur High Court at the moment is a sensitive high court because the northeastern state has been in grips of a prolonged and violent ethnic clash which requires court's intervention. Today, a bench of Justices Sanjay Kishan Kaul and Sudhanshu Dhulia was hearing a petition filed by Advocates Association of Bengaluru seeking contempt action against Union Ministry of Law and Justice for not adhering to the timeline set by the Apex Court in a 2021 judgment for clearing collegium proposals. In July this year, the Supreme Court Collegium, comprising CJI Chandrachud and Justices Sanjay Kishan Kaul and Sanjeev Khanna, had proposed the appointment of Justice Mridul as the Chief Justice of Manipur High Court. Despite the passage of almost 3 months, his name had still not been cleared by Centre. But today, the central government has assured the court that his file has been cleared and the notification will be issued shortly. The bench recorded in its order the central government's assurance. And lastly, the Supreme Court has put a closure to all cases pending in different high courts against the movie Adipurush. While hearing a petition filed by the producer of the film seeking to transfer to the top court cases from different high courts, the court ordered a closure to all such pending proceedings. These impugned petitions are pending in the High Court of Rajasthan, Punjab and Haryana and Allahabad, seeking to ban the movie and quash the Central Board of Film certification granted to it for allegedly hurting sentiments of Hindus and devotees of various deities depicted in the movie. The bench of Justices Sanjay Kishan Kaul and Sudhanshu Dhulia said that the film, now having been released, all the proceedings related to it filed in different courts were futile exercise which must stand closed. Thank you for joining us. If you wish to know more details about the cases I mentioned here, you can visit our website at www.livelaw.in. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us. You can also support us by donating through the thanks button at the bottom of our videos or consider becoming a member at just 89 rupees per month.